Our second case is also out of Wyandotte County. It's case number 128738. Joshua Sammons, an individually and a special administrator of the estate of Brandy Sammons, appellant, versus the University of Kansas Hospital Authority appellee. Would the parties please state their appearances?
Michael Planton on behalf of the appellant Joshua Sammons, Your Honor.
Thank you.
May it please the court, Trevin Ray on behalf of the defendant appellee, University of Kansas Hospital Authority.
Thank you. And Mr. Blanton, would you like any time for rebuttal?
3 minutes.
3 minutes are granted. And with that, you may proceed.
Defendant would have this court believe that this case involves complicated issues of policy determinations regarding organ transplants. That's simply not the case. This is a basic medical negligence case in which a hospital failed to maintain its own internal records and it failed to communicate with its own patient. But before getting to that core issue, I'd like to briefly touch upon the disqualification issue in this case. There's no question that Judge Mahoney's sister served on defendant's board, and Judge Mahoney should have disqualified himself because of that fact. The Kansas Code of Judicial Conduct, Rule 2.11A2, says that a judge shall disqualify himself under those circumstances, and the case law has recognized that those circumstances require disqualification. And Judge Mahoney agreed at the hearing. He had known that his sister was on defendant's board, and he conceded that he had never given the parties or the attorneys any notice of that fact. And so the judge should have disqualified himself, but not just at that moment when it came up at the hearing, because the comments to Rule 2.11 state that it's a judge's obligation not to hear or decide matters when those circumstances are present, regardless of whether a motion to disqualify is filed. So when a judge has the conflict that we've identified under 2.11, a judge shouldn't just wait to see if anybody raises it and address it on a motion if somebody files a motion. A judge should recuse himself from the beginning of the case under that standard.
Counsel, while I appreciate the seriousness of what you're discussing, we also have a lot of case law that discusses the fact that just like the rules of professional conduct for attorneys are not dispositive in, say, a legal malpractice claim, neither are the judicial canons dispositive as to whether it's not structural error. We still have to show that there is some kind of a prejudice that it's affected the outcome. And what can we point to show that it affected the outcome?
I would disagree with the premise because I don't think there is a requirement of bias or prejudice under 2.11A2. Under 2.11A1,
I'm not talking about the canons. I'm talking about a recusal case law, which says that there has to be a showing of prejudice. It's not a structural error. So what is the showing of prejudice or bias that you can point to?
I don't think there is an express showing of bias. Again, the basis of our complaint isn't prejudice, although the rule speaks in terms of circumstances in which impartiality might reasonably be questioned. And I can tell you, our client certainly questioned the impartiality of Judge Mahoney after learning of the conflict that Judge Mahoney had. But aside from that, I still disagree with the premise. The Supreme Court has recognized on multiple occasions that there are separate bases to seek the disqualification of a judge. KCJC, the statute, which speaks to bias and prejudice, and due process.
And was the statute followed here? Was there a petition that was presented to Chief Judge Burns?
No, but we weren't pursuing disqualification under the statute, and the Supreme Court, it was in the...
But you're claiming reversible error now?
We are claiming reversible error and not that the judge should have disqualified himself. We're claiming that the opinion should have been vacated because the judge should never have been sitting to issue the order that it did pursuant to the KCJC. And the Supreme Court has recognized that they're alternate bases. The KCJC and the statute are two separate bases. The language of the cases literally says 3 different bases to seek disqualification. So if you're seeking disqualification under...
With the affidavit with the chief judge.
No, because again, that's part of the statute. That's part of 2311. We weren't proceeding under
But if you wanted him to be disqualified, why not pursue all of those avenues.
Again, it is another method that was available to us. It wasn't the method we used, but we did use KCJC, and the Supreme Court has repeatedly said that is also an alternate basis for seeking disqualification. The language of the Supreme Court cases expressly recognizes that. So I don't think we were required to use one method over another. The case law doesn't speak in terms of that.
The statute provides the complaining party an option for somebody other than the judge that's being asked to recuse to decide whether he or she should.
And I'm not arguing about how the statute works, Your Honor. Again, we weren't proceeding under the statute. We were proceeding under the KCJC, which has been identified as an alternative basis for disqualification by the state Supreme Court. I'm happy to answer more questions. I hate to spend too much more time because I'd like to get to our core issues.
More on point, in my opinion.
Okay, I will move there right now. So again, defendants suggest that this case is about the national transplant system and policy decisions, but this is really just a medical negligence case. And to see that, I think it's important to look at where the negligence occurred. There's no question Brandy was on the transplant list. Nobody disputes that. And when somebody's on the transplant list at any given moment, their status is either active or inactive. And the way that happens is the hospital communicates that back. It's like there's a switch. You switch it on for active, you switch it off for inactive, and that comes from the hospital. And in this case, Brandy had a brief episode of bleeding where she was put on temporarily inactive status. But the defendant then failed to flip the switch back on, which should have happened fairly quickly. And there's no dispute that Brandy was erroneously maintained in a temporarily inactive status for a significant period of time. The district court literally held in its own judgment that it was erroneously maintained temporarily inactive status. So there's no question that the hospital made a mistake.
Would it ever have been proper for her to be in temporarily inactive status, or was it just a miscommunication between the physician and the person who actually typed in that trigger?
So frankly, there's a dispute about whether she should have ever been inactive at all. But assuming that she was, it was for a day or two, and she should have been quickly moved back to active status. And again, the district court recognizes it was erroneous to leave her on inactive status. And defendant recognized that there was a period of nearly 2 months from September 8th to October 27th when she would have been eligible for receiving organs. And defendant's experts have explained that she likely would have gotten one, and that likely would have saved her life. But not only did the hospital fail to keep adequate records, the hospital also failed to communicate with its own patient. It was the hospital's practice that when a patient was put on inactive status, they would inform the patient of that, and they didn't inform Brandy.
Who has the power to put somebody on the donor list or take them off?
It's an entire process. To be frank, Your Honor, I don't know all the details of the ins and outs, but again, there's no question in this case about whether Brandy should have been on the donor list. She was on the donor list. This case isn't about whether she should have been on the list or not. It's simply about whether that inactive switch should have been flipped back on to active rather than being left in the inactive status. And the hospital also, not only did it fail to inform Brandy she was on inactive status, but the hospital then on 2 occasions when Brandy contacted the hospital to ask about her status, the hospital erroneously told her that she was fine. She was active. She was still on the list. So we have 3 separate acts of negligence, and the court should have dealt with those from the perspective of the reasonable standard of care. Kansas courts have long recognized that that is the standard for a hospital, it's in the PIC instruction. A hospital's duty is to use a degree of reasonable care required by that patient's known physical condition. That's the long recognized standard in Kansas. Rather than focusing on that standard, instead, the court looked at the specific task, and it defined the duty in terms of the specific task. And can I get a drink of water real quick, Your Honor? I apologize. I woke up a little raspy this morning, and
These allergies, right? These allergies. Welcome to July in Kansas.
I apologize for that.
It's no problem.
So the judge should have addressed the duty from that perspective. And the duty arises from the hospital-patient relationship. It doesn't arise from the specific task that the hospital happens to be engaging in. And that distinction is important, and it was addressed recently by the Kansas Supreme Court in the Reardon decision. The court recognized in Reardon that we apply a reasonable standard of care. And the reason we do that is because it allows courts to avoid, quote, infinite factual circumstances that could exist. So in other words, rather than having 300 separate duties that a hospital might violate, depending on which specific action you happen to be talking about, we have an overriding duty of reasonable care. And it's a jury's job to decide whether specific actions violate that general duty.
As I read the district court's decision here, the district court essentially concluded that because there is not a common law duty to, or there isn't any right to be placed on the list to begin with, then that means that anything having to do with that list doesn't trigger a negligence claim. Is that an accurate description of the finding?
I think that is the essence of the court's finding. I think that's absolutely incorrect, both factually and under Kansas law.
So where is the action? I think that you've identified three things, but could you help me just parse it out a little bit more? Why is it that despite the fact that there is no common law right to be placed on the list, that we nevertheless can reach the negligence claim in the absence of any kind of triggering right?
Well, again, first of all, we're not talking about the right to be placed on the list. She was on the list. Nobody disputes that. There's no question. The error was the hospital's own record keeping error. It failed to update its record to note that she was inactive. Its record still said it was active. Do hospitals generally have a duty to appropriately keep their own records? Yes, they do under Kansas law, but it's not a specific duty about record. It's their general duty of care. Do hospitals have duty to communicate with their own patients? Yes, they do, but it's not a duty about a specific task. And when we talk about, defendants raise this idea that, well, because transplants are heavily regulated at the federal law, this is just different. Medications are heavily regulated at the federal law. And yet that doesn't change Kansas law of negligence. We frequently have cases with hospitals involving medication errors. Defendant similarly makes the argument that, well, the federal law doesn't create a private cause of action. But again, medication's highly regulated, and those medication regulations don't create a private cause of action for somebody to complain about a medication error. But Kansas has long recognized that medication errors are an appropriate basis for a negligence claim. I see my primary time is out. Unless the court has another question, I'll wait for rebuttal. Thank you.
You have 3 minutes that are reserved for rebuttal.
Morning, may it please the court. We have a mild disagreement on the order of presentation here, and if it's okay with the court, I will address the right of action first and then the other issues after that, just because I think that predominates. One of the things that that's sort of lost in this is that we would not be here talking about anything but for the National Transplant Waiting List. That is a creation of federal law. So in 1984, the federal government passes this act that leads to this final rule that is the creation of the list. And the background for that act was attempting to make good stewardship of organs that become available, get them to the right places where they can be used and avoid wasting, and then also to eliminate an emerging black market where you sell donor organs to the highest bidder. So this standardized the entire process. It created this list, and it created the concept of being a transplant program participating in the list, which you must be. So the University of Kansas Hospital has a transplant program for certain services. Each hospital declares what they can and can't do on that, but they all must participate in the list. So the list itself, it's undisputed here. There's no right of action in the statute that allows somebody to contest their status on the list or whatever, take some action seeking to gain status, keep status, override medical decisions, whatever that is. That is not a statutory cause of action granted. The question here is, can you simply do an end around on that by affixing a common law negligence label to exactly the same thing? And so here,
So I want to stop just a little bit. And are there any common law negligence claims that could arise out of a transplant
transplant generally.
generally?
So once you endeavor to undertake the medical care, I think that you convert over to the usual medical standards. If you're
And when does one convert over to the medical?
when we're doing a transplant surgery. So if I can back up a step, if it would help, I can talk a little bit about the transplant process. If you look at, so what are all the stages between potential candidate and transplant recipient? There are lots of people sent over for evaluation, and a committee of physicians has to decide, is this person a valid candidate to be on the list at all first? So that has a myriad of things that by regulation are set out they have to consider. They include things like behavioral issues that might affect compliance, because you have to maintain a rigid compliance with anti-rejection regimens and things like this. It might include whether or not the person has past issues that may be repeated that would cause you to lose the organ. Now, nobody gets it. These
Now,
kinds of,
we can fast forward through this
Sure.
because Ms. Sammons was placed on the list.
she was, but what they're asking for here, they can't just say, I want a common law cause of action for these facts. They are saying Kansas will be the first state in the country to, notwithstanding the National Organ Transplant Act, recognize a new cause of action that allows somebody to litigate status on the list. That's the point of error, is that
But it is not, it isn't, it's a fact question, isn't it? The KU agreed to put her on the list and by error took her off the list.
well, she didn't come off the list. That's one of the things you're opening this up.
Well, I mean, she became from active to inactive.
Right, which temporarily inactive. This is a thing that's required by
Well,
regulation.
boy, that temporarily inactive period was unfortunate.
She missed 5. She was first on the list for 5 transplants, wasn't she?
No,
During that inactive period.
well, no, we would contest a lot of the facts, but we're
But this
using
is
a
at summary judgment.
That's what I'm saying. Yeah, we're assuming a lot of things on their behalf, but really it's a question of law.
Can we also assume that it was erroneous to place her on temporarily inactive status for summary judgment purposes?
I would say that it's right to conclude that the evidence was the internal designation and the actual listing status did not match. She was made temporarily inactive on the national transplant waiting list. Whether that was an error or the other one is a point of debate, but you can assume there is disagreement between those two, and you wouldn't normally have that.
So once the hospital, following this process that you had described, which is seems like a very rigorous process to place a person on the transplant list. Once the hospital has decided that this person should be placed on the transplant list, do they have no duty of care toward the person to make sure that they aren't, that the hospital doesn't screw up to remove that person temporarily from a potential transplant?
Well, so the question though is, do they have a common law right of action in tort to claim, like they say here?
Do they have a duty of care toward their patient?
Well, that's the point. At that point, are they a patient or a candidate? What I'm saying is, once you undertake the medical procedure itself, it's a lot more clear that you have the medical duty of care that applies. But at this point, when you're talking about enforcing status, they have a duty of care. If they did, let's say, I mean, would that then give you a right of action that arises out of the subject matter of the National Organ Transplant Act? Because there's not
But is this out of the subject matter of the National Organ Transplant List, or is it just hospital as part of this person's treatment, place this person on the list, whether, following all the procedures? It's not like she had a cause of action to be placed on the list, but hospital has placed her on the list, and then through hospital's error has prevented her from actually receiving the benefit of being on that list.
What's the universe of claims? You're not supposed to answer a question of the question, but forgive me.
Why don't you answer my question?
Well, that's what I'm going to try to do. The question is, okay, so let's say that there's a medical decision that she should be temporarily inactive. Does she have a cause of action in tort to litigate? I think that was a result of negligence. I think that decision should have included another evaluation, or it was an unreasonable judgment. I'm saying now in tort, I had the right to be on the list, to stay on the list, and to stay in active status, such that then now you're litigating those things. Would you have a cause of action then to say, I don't think the surgeon should have rejected an organ as not having sufficient quality to be transplanted? Because that's the other thing.
That's not the question that we have. The question we have is whether under the facts of summary judgment, right? Taking everything in the light most favorable to the non-movement. Whether, given the error by the hospital as to basically flipping the switch and putting you on in temporary inactive status, assuming that that was erroneously done, then is there no recourse?
Well, when you talk about recourse,
Is there no recourse in the law? Was there no duty of care that was owed to the patient?
well, there's no enforceable action of negligence that arises out of a status on the list. That's because that would have to be granted by the authority that creates the list
But
itself,
who has the power to put a person on the list?
a transplant committee. And they have,
The hospital.
well, the hospital's transplant committee, but it's made up of physicians. This gets into an irrelevant issue.
Right, but I mean, but it's in essence, the hospital has the authority to put a person on the list. And the hospital has the authority to maintain that list.
On the orders of its physicians. That's why I say it's.
Well, I understand that.
I'm not trying to.
But we're not but I'm just trying to get to who accepts the duty to put a person on the list.
That's, I think what I'm saying is I don't think you ever have a duty to put somebody on the list. I don't think that that is a medical judgment.
But once you put somebody on the list, who has the duty to properly maintain the eligibility on that list?
Well, so that's, I think, what gets to the point, right? Is when we talk about properly maintaining eligibility, then they're asking for the opening of a new cause of action that arises out of the list. It would not be limited to, does this match this? It would have all of you would just get to claim a duty of care and that it includes whatever you list that to be. And you can say you have a duty to evaluate me correctly. And I think that was breached. You have a duty to reach the right conclusion. I think that was breached.
That's not their claim, is it?
Well,
The claim is that the failure to maintain the list.
well, that's their claim. That's part of their claim. I agree with that. But that's not what the question of law will be. The question of law will be, is this state going to be the first in the country after 40 years to recognize a common law right of action that affixes a negligence label to the exact same conduct or the exact same subject matter that is in the Transplant Act of 1984? And keep in mind, of course, this was raised and the challenge was presented, okay, find a case where this has actually been allowed to go forward. And that there has been none. They've cited 4 cases in the briefing. 3 of them are federal district court cases. 1 is an unpublished Michigan Court of Appeals case, and none of them is actually on point. And if we wanted to discuss that, I would get into that. The point here is that they have not been able to identify if it's existing common law that allows this. Where are the cases where this has been allowed?
It strikes me, though, that this is a factually unique situation because in many cases, there could be an allegation, but it would be very difficult to talk about causation. Whereas here, there at least seem to be some facts, again, at the summary judgment stage, but there seem to be some facts that put causation into play. So I mean, the fact that there are no cases doesn't surprise me.
Well, I think you would have to think along the way that people who want to be on the list, at some point, there would have been something that arose out of this, something that alleged or court said, yes, you can claim status. Remember, this is what the core of the claim is. It's a claim to active status, a specific status, not just something.
Is it a claim to active status or is it a claim? And maybe we're just going round and round on this, counsel, but is it a claim to a particular status or is it a claim that the hospital erred and by that error prevented me from accepting a transplant that otherwise would have been available because I was on the list?
So can I break that into 2 parts really quickly? The first is the claim of error. I mean, says this. It says the hospital owes no duty to maintain a person as having an active status on the national transplant list when such status is warranted. We may quibble with how that phrases the district court's order, but that is the core of it. They are claiming a right to active status enforceable in tort and hindsight. And they've now pointed to Reardon as suggesting, I don't think it's correct to interpret Reardon as an attempt to basically broaden Kansas tort law to the point where it becomes a big due process violation where you absolutely never know what your obligations are such that you can comply with them when they're affirmative acts. The Reardon itself said we're not splitting the claims. I mean, that was the context for that case. So you can bring causation into a lot of things. That's often going to be a debated point, but where the rule of law exists is to say, even in those times, this is just not a box we're going to open. And here, that is absolutely what they're asking you to open, is this box that says people can now come in Kansas and litigate their status on the list and say it should have been active. This is what gets to the causation issue you raised just a minute ago, Your Honor. There are a myriad of steps between placement on the list and receiving a transplant. And that was much of what was glossed over in some of the briefing underlying and then on appeal. I mean, I know you don't want to, I don't want to take the rest of my time going through all of them, but there are a bunch of judgment calls. You can get an organ offer and not get a transplant. That happened to Brandy Sammons once when there was an offer, but the surgeon said that is a pancreas of insufficient quality to transplant. The organ offer becomes immaterial at that point. None of this is material unless you are claiming an entitlement to eventually undergo the transplant itself. That's the other end of this. And there are a myriad of things. You have to come to the hospital to get there in time. You have to be in a reasonable condition such that you can withstand the surgery, et cetera, et cetera. And those are all judgment calls.
Questions about proximate cause are so tricky, right? But the ultimate question as to whether we have a cause of action at all kind of presumes that those could be made, those showings could be made.
Well, it would open the right to litigate each of those decisions. So you could litigate each of those against the surgeon, say, I don't think it was of insufficient quality, and I think that was a negligent evaluation. You'd open all of those things up for examination, and you'd put tort litigation finger on the scale of deciding who does and does not have a chance to get transplant, because there is far more demand than there will ever be supply. And
could you, and I just being wary of our time, I am troubled by the relationship between the district judge and the board member. I find that very troubling. Are you troubled by that?
I would say that am I troubled by that just in the abstract? I would say no, because I didn't see any manifestation of bias. It was not something that was discussed, and I don't think
well, I mean, it wasn't discussed because he didn't bring it up.
Right. And I say, when you say, are you troubled by it? I think I'm not trying
as an officer of the court.
Sure. Well, so this gets into a different discussion about we're probably the worst people to be heard on this, which is why we said, look, this is a matter for Judge Mahoney doesn't have to rely on us to speak for him. Who would listen to us on this point anyway if we don't make the connection, kind of a thing. But ultimately, the overarching premise of that rule is when a reasonable person would question impartiality. That's the premise, right?
Well, let me jump in on that,
Sure.
because his order denying the motion for disqualification said, for the reasons stated on the record, the motion is denied. Well, I went back and read the record last night, and he didn't give a reason. And so would that in and of itself, the fact that, yeah, my sister is on the board, but I stand by my previous decision. And that's pretty much it. You can appeal me. I mean, that's pretty much it. Is that in and of itself, the fact that he didn't really address it at all, is that evidence of bias?
I don't think I don't think it's on its own evidence of bias. I think that the idea of bias would be as it manifested in the actual order that is being challenged. And remember that they're claiming it was void. I mean, that to me is the more essential question is this order totally void? Because the idea is he should have disqualified the first. I mean, that's one of those things where you can't weigh in on that if you're me, because I can't tell you what the judge knew. I can't tell you what he concluded about when a reasonable person would. I mean, for example, let's say he hypothetically concludes, yeah, but that rule doesn't mean uncompensated membership on a 19-member nonprofit governmental entity board or whatever. That, that's up to the judge to decide, not for us to declare it. And so is that manifestation of bias? I would say I don't think on its own it would be, but then is that then representative of bias in the final order? I say absolutely not, because that's just a pure question of law. He in fact treated all the facts and as in the light most favorable to the plaintiff. There's no evidence he discounted some facts because he or made statements that suggested he wanted a certain outcome over the other. I mean, all of the cases in the Kansas case law have, as Judge Warner identified, spoken of, okay, what's the ultimate effect on the outcome? Because this affects the litigant, right? If this order is void, sorry, quit doing that, then we start over, right? That's the idea. So there's not even an allegation that if there, let's say, was some sort of internal bias, that it produced something that alters the proceedings, because it's a pure question of law. So I've gone way over my time, sorry.
But isn't it the opportunity to avoid the appearance of an impropriety?
You mean the disqualification
Right.
part? So
I mean, the judge has a self-internal clock that should say, hey, maybe I should step out of this. There's other judges that can do it. If not, somebody else in the county can't do it, then the Supreme Court can assign somebody from out of district.
that absolutely is an option for them. That's why I say, I mean, I'm struggling here just because I'm
Well, I know,
him on an ethical basis.
but I'm just saying, I'm not trying to put the ethical side of it. I'm just saying the appearance.
Well, would a reasonable person question impartiality in this scenario? That's, I think, ultimately what that rule requires him to decide. Now, it does have a sub, I'm not disputing this, as a sub that says we would presume that if these things, but it goes really far, and it says third degree and their spouses, partners, they're on a board. It doesn't specify what kind of board. You have to have an economic interest. I mean, what are the situations that allow you to conclude a reasonable person would say this thing makes me question whether he's impartial? And it does leave it up to the judge to subjectively determine. Would it avoid it if you did that? Sure, I guess, but it also opened it up to weaponization, I guess, at some point, if you're going to, after the fact, claim, well, we should just invalidate everything that happened. That's, to me, that's the difference between, like, there is this separate question. I don't purport to speak for Judge Mahoney. I think he should have the right to answer that question himself. But the effect is ultimately the question here is, does this void everything that happened? I think that the law says no, even if you conclude, well, it would have been a better idea to avoid it by not, by recusing or disqualifying.
Thank you for your answer.
Thank you, Your Honor.
Thank you. Thank you very much. Counsel, you've reserved 3 minutes for rebuttal.
Thank you, Your Honor. Defense counsel said repeatedly that we're seeking to create a new common law cause of action, and that's simply not true. There's already a common law cause of action. It's called negligence and has been recognized by Kansas courts for a long time. And not only that, we have an instruction, a PIC instruction based on Supreme Court cases, which tells us exactly what the hospital's duty of care is in a negligence action against a hospital. There's nothing new here. Even defense counsel concedes at some point the hospital has to be responsible for its own actions. Defense counsel wants to draw that line when the moment the surgery starts. Respectfully, I think the line is way before that. I see no reason why this case should be different than any other, where a hospital is responsible for its own actions that relate to the care of a patient. And that can be record keeping, and that can be communication with the patient. And the district court acknowledged in its own order, we have errors in both of those. There's errors in record keeping, and there were errors in communication. So I don't think we can just pick a line and say, well, it's once the surgery starts. The hospital's failure in this case is so clear-cut. And again, there was a lot of discussion about the list. Defense counsel spent a long time talking about the list and the policy considerations. Brandy's already on the list. Nobody's questioning that Brandy's on the list. And not only that, this isn't even a case where we're really arguing about the hospital's decision-making process in terms of being inactive, because even the court recognized she was erroneously maintained in a temporarily inactive status. And the important word there is temporary. That was the whole idea. She should have been temporary, if at all. She would have been temporarily put on inactive status and then quickly switched back on to active status. And that was the hospital's error here. And then not only that, the hospital compounds that error by never telling her she's been put on inactive status. And in fact, when she calls to check at least twice, telling her the opposite. No, you're active. Everything's fine. You know, you are on the list. You're available to get organs. So
Counsel, before you conclude, I'll tell you something that I have been struggling with, and that is there is no common law right to a particular status on the list, right? And there is no private right of action to have a particular status on the list. The case law is pretty clear on that. So what distinguishes this case where there was an error or a series of errors from a case when someone is arguing, the hospital decided to place me on temporary inactive status, but I should never have been placed on temporary inactive status, which seems much closer to the I want to be on the list, but I don't have a common law right of action to being on the list. So what distinguishes this case from just a disagreement as to what your status should be?
I think it's always going to be fact specific. I mean, if the reason that, and again, those aren't our facts. The dispute here is
But
not
we have to
about the
think about,
decision.
we have to think, when we're writing an opinion, we have to think about this case.
You know,
We have to think about the way that our words are going to be interpreted later. And so what distinguishes those two scenarios?
so because I think it's a error that occurs solely within the hospital. That's why I talked about it's important to look at where the negligence occurs. This was a hospital record-keeping error here, the hospital's failure to keep its own records, and that's not something new. There are many cases that involve hospitals failing to keep accurate records in one respect or another, and this case should be treated no different than any other medical negligence case in that respect. The same with communication. I mean, again, we don't define duty in terms of what specific task we're talking about. We define duty in terms of the overall duty of reasonable care. And I don't think transplant cases are treated differently in that respect. Again, same with medication, as I noted, highly federally regulated area of the law. There's no independent federally created cause of action for a medication error. But there are many cases where Kansas courts have recognized that when a hospital or doctor makes a mistake about medication, that's actionable. Doesn't make any difference that there's a federal system for determining which drugs should be legal and which ones shouldn't, and how we triage drugs. None of that makes any.
I think that answers my question. And I did interrupt you right as you were closing. So if you'd like to take a few seconds and close.
Yeah, and just in closing, I appreciate that, Your Honor. Again, this order should have never been issued because Judge Mahoney should have been disqualified from the beginning of the case, and the order shouldn't have been issued. But even if you do look at the order, I think the judge's order is entirely inconsistent with Kansas law regarding what the duty of care is for a hospital. I think that's been true for a long time, but I think it's especially true given the Reardon decision. And I would note the Supreme Court has doubled down on that analysis 2 times since the Reardon decision. Granados, and I believe it was 22. And then again, just last year in the case of Stroud v. Ozark National, 320 Can 180. So this wasn't a case where the Supreme Court said something inexact and it's not clear what they really meant. The Supreme Court has emphasized it meant exactly what it said. And in the Supreme Court's own words, duty rules are not meant to be fact specific. That's where the trial court erred here, Your Honor.
Thank you very much.
Thank you.
I want to thank both counsel for your arguments today and for your written briefs. A very interesting case. We'll take the matter under advisement and we'll issue an opinion just as soon as we're able.